Hello there. Welcome back to An Architect Goes to Law School. Having discussed the laws and processes for becoming an architect, today in Legislation and Regulation class we'll be talking about license maintenance. After passing the ARE and earning an architect license from a state licensing board, individuals have to maintain those licenses. First, we'll talk about complying with licensing acts, rules, and regulations. States' licensing acts are the methods by which the states have the power to regulate the profession of architecture. What you have to comply with, however, is usually found in what are called the rules and regulations. Most of these rules and regulations are detailed and thorough in describing the obligations architects must follow in order to maintain their licenses. Generally speaking, anyone wanting to be an architect in the U.S. should research and learn their intended state of practices licensing act to determine whether there are any unique portions of those laws. Rules and regulations often have section headings such as authority, scope, purpose, definitions, architect registration exam, practice rules, continuing education, disciplinary actions, and professional standards. Now for a sampling of rules and regulations. The Architect's Handbook for Alabama explicitly states the reason for all states' licensing acts. Section 100-X-4-.01, titled Public Interest in Registration of Architects, reads in part, quote, Architects in the practice of architecture are hereby declared to affect the public health, safety, and welfare, and to be subject to regulation and control in the public interest. End quote. Guam's Rules of Professional Conduct for Professional Engineers, Architects, and Land Surveyors has two interesting clauses. First is that, quote, all persons registered are charged with having knowledge of the existence of the rules of professional conduct and shall be deemed to be familiar with their several provisions and to understand them. End quote. While not necessarily explicit in some of the licensing acts, this constructive knowledge of their contents is to be expected of all licensed architects. Constructive knowledge is the legal assumption that a person should be aware of some information or laws based on responsible behavior or reasonable level of attention. As the saying goes, ignorance of the law is no excuse. Guam's second interesting clause is that a post-licensure felony criminal conviction, if for something that would violate another portion of Guam's codes, may itself be a violation of the rules of professional conduct. Rhode Island's Rules and Regulations for Architects, Section 1.12, Professional Standards, Paragraph E, Professional Conduct, directs licensed architects to only sign and seal documents over which the architect was, quote, in responsible control over the content of such technical submissions during their preparation and has applied the required professional standard of care, end quote. This standard of care concept is critical to all architects' practices. Another section of the Rhode Island Rules explains its standard of care as being, quote, acting with the reasonable care and competence and the application of the technical knowledge and skill which are ordinarily applied by architects of good standing practicing in the same locality, end quote. This reasonable care and competence simply means that if many architects in that locale are engaging in a particular behavior or custom, as long as such actions are not in violation of the law, then that is the standard of care. This is the baseline by which architects' professional actions are judged. We'll talk more about standard of care in future videos. Georgia's OCGA Section 43-4-18 contains information about its licensing board's ability to impose a fine for violations of the Licensing Act. This fine shall not exceed $10,000 for each violation. Importantly, the code also states that each day a person is in violation is a separate violation. Ohio's Revised Code Section 4703.15, Disciplinary Actions, Fines, also permits the state's Architects Board to, quote, deny renewal of, revoke, or suspend any certificate of qualification to practice architecture, end quote, if the architect before the board has been convicted of a felony by a court of justice. This highlights the point that even an architect's behavior outside their professional life may impact their employment and licensure. Idaho's Title 54, Professions, Vocations, and Businesses, specifically Chapter 3, Architects, has an interesting section that permits someone who is already a licensed architect in another state and has applied for an architect license in Idaho to be given a temporary license. Idaho's temporary license clause contrasts with Kentucky Law 201 KAR, Chapter 19, Regulation 250, which explicitly reads, quote, temporary registration, licenses, or permits shall not be granted, end quote. All of these examples are meant to give a sense of the breadth of the various states' rules and regulations controlling the practice of architecture. Feel free to comment, ask questions, and suggest topics you'd like me to discuss. Next up in legislation and regulation, we'll continue with license maintenance by talking about continuing education requirements. Thank you for watching An Architect Goes to Law School.